Hey guys, today I will tell you about criminal law in India. Criminal law in India refers to both crimes and misdemeanors that are against the state. For crimes, the burden of proof is beyond a reasonable doubt. The Indian Penal Code, the CRPC, the Eviction Act, and other laws control criminal law. A set of laws and regulations that outline behavior that is illegal under the law because it endangers or affects the public safety and welfare, and that spell out the penalties that will be applied when such behavior is committed. What is the meaning of criminal law? Criminal law refers to offenses for which penalties are established. Criminal procedure, on the other hand, describes how criminal laws are enforced. As an illustration, the criminal law that forbids murder is a substantive criminal law. It is typically thought of as a procedural matter how the government enacts this substantive legislation through the collection of evidence and prosecution. Legislation related to criminal laws in India. Indian criminal law is composed of three main acts: the Indian Evidence Act 1872, the Code of Criminal Procedures 1973, and the Indian Penal Code 1860, a substantive law that outlines right and obligation, etc. Is the Indian Penal Code. The guidelines for how substantive laws can be applied are laid forth in the Code of Criminal Procedure. In India, a plethora of minor laws are created. Indian Penal Code 1860. The Indian security system has undergone several testing and evolution throughout the years. The nation's political and socio-economic situation is the cause of Indian security system. India is a country with many different customs and civilization. As a result of the people, cultural variety, and conflicts of interest between various governments, ethnic grouping, and cultural consortiums, there are disputes among the people. Additionally, there are several attacks by terrorist groups and neighboring nations. Subsequently, there is the Naxalite problem and regular crimes that happen every day. A legislation has been created to address all of these crimes and legal violations. It addresses each of these instances separately and outlines the punishment of individuals found guilty of any of the listed offenses, which is known as the Indian Penal Code. In its most basic form, the Indian Penal Code is a book that contains all the possible charges and penalties that may be brought against someone who commits a crime. It applies to everybody who is an Indian citizen or has Indian ancestry. The exemption in this case is that no crime committed by members of the armed forces or in the military may be prosecuted under the Indian Penal Code. The Indian Penal Code does not have the authority to replace of any of the laws that apply to the armed service of the military. The Indian Penal Code also has the authority to prosecute any offences committed by an Indian citizen aboard an Indian ship or an aircraft that belong to India. The British ruled India at the time the Indian Penal Code was first written. It is recognized as having its roots in a British legislative narrative or colonial victories from the year 1860. Under the capable guidance of the Initial Law Commission, the Indian Penal Code's first and most basic draft was created in the 1860s. Lord Maxwell dutifully presided over the commission. In the year 1862, the first criminal code was created. It has undergone several revisions since in order to adjustment and jurisdiction precision.